right, I think we can start. So after the last panel, I'm not sure what we can possibly say that would be interesting to the audience here. But we'll try our best. And then we were told that we should start with a comment on why this topic is interesting or important. So far, I was gonna quote on some kind of trillions of dollars invested, blah, 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 boring. But so far, it seems like nobody knows what FRAND is. Nobody can decide on FRAND. Courts may or may not be the right place to go. Jury, no good. SSOs, not doing their jobs. ADR, nobody wants to use it. Where do we go from here? Nobody has blamed the government yet. We can cover that in this panel. So for these reasons, this topic, it's important. That's why we will continue to explore the problems and hopefully some solutions of FRAND and SEPs. And I'm very excited to introduce my panelists here, but before that, I forgot my own name. My name is Jane Bu. I am the head of legal at VIA Licensing. For those of you who doesn't know, VIA is a patent pool administrator, and I've been practicing patent law for about 20 years. And prior to going into the dark side, I was a medicinal chemist, but keep on setting myself on fire. So I figured practicing the legal arena is a little bit safer, which ultimately led me to here. And our panelists is a group of highly recognized, accomplished IP and legal practitioners. And they're here to share their insights and a wealth of knowledge and perhaps be a little bit goofy after the last panel. So sitting right next to me is He Jing, who is a partner at the Gen Law firm, which is a leading IP law firm in China representing many international as well as domestic clients. And he started his IP career in Silicon Valley, actually, for 10 years, then started his private practice in China for the past decade. And not surprisingly, He Jing is also a policy advocate in China, and Gen Law firm has a consulting arm that specializes in geopolitical issues, and we will definitely explore that. And sitting next to He Jing is Cono. He is a trial lawyer who focuses on high-tech cases and specializes also in ITC and in front of USPTO. And in his prior career, he designed supercomputers in AT&T Bell Lab. And then Cono told me when he's getting ready to come to this conference, his 3-year-old daughter asked if he will bring back a real dragon from the conference. And I think you can tell your daughter, FRAND discussion is way more exciting than any dragons. And then sitting next to Cono is Irene Yang, a partner at Sidley, the co-leader of Sidley's IP litigation practice. She focuses her patent litigation high-tech cases involving technology such as networking and telecommunications, as well as FRAND and SEPs. And Irene told me the next language she wants to learn is German. And as the patent litigator, I think I can guess why. A wild guess. And then finally, but not the least, is Tim. He is the founder of IPlytics. And if you do anything to do with SEPs wireless licensing, you should definitely know what IPlytics is. And he is a world-renowned economist and a member of European expert group on FRAND and SEPs issues. And Tim told me he used to play American football for 10 years. And, and he is a wide receiver, and I am still in shock about that. And he's never played basketball, even though he's really tall. So without further ado, I think we can start our discussion. So first question, I think that we heard from our previous panels actually, on the usefulness or properness or just basically commenting on the adjudication of worldwide FRAND rate, whether it's the right place in court or not. So we can explore this particular issue through perhaps from the practitioner's point of view. So He Jing, you are a practitioner in China, and there are a lot of activities coming out of China right now, and it seems to be a focal point. So given the current landscape and the recent Oppo cases, Oppo versus Sharp, Oppo versus Nokia, Can you tell me what does that mean for licensors who's seeking a license from a Chinese company? In other words, what I'm really asking is, can they avoid being dragged into a Chinese court?
They probably cannot, actually. These days, when we talk to the clients, when they are the patent owners, they say, hey, I want to do this in China. I said, well, you got to be ready to deal with, say, a FRAND raid case and also probably a antitrust private action in China as well. This is something you have to deal with. But the one thing I do want to distinguish here, because it's very easy to looking at what's going on in China from what you already know, especially from the US or Europe. And you're looking at the court action, the decisions, you will say, wow, that's like the court decision. But however, I do, with all my 20 years experience, I do think we have to really distinguish something. Some of the decisions coming out of Chinese court, you probably see, I use a word, I just stole the word from USTR, the toolbox, rather than precedents. I mean, here, when you're looking at a court decision, here's a case law, right? You automatically attach really, really strong meaning to that. But however, in China, even though for this global FRAND rate decision, the jurisdiction, yes, looked like a little bit controversial, right? The same kind of a controversy you saw from out of the UK court. But I personally argue that that could be just one of the toolbox Chinese courts having these days in reaction to what happened in the UK court. One of the reactions we heard from the Chinese judges and scholars is that they feel like, hey, how come your UK court can do this, we cannot? Right? Here's the biggest market, or the most patents are being practiced here, the negotiation happens here. How come we cannot do that? Our Chinese judges, I've shared a little bit of what Judge O'Malley just said. I mean, the judges are very wide smart. They can do it, but it's too much work. Chinese judges have the same feeling. They feel like they can do it too. And that's why they take on this case from this local court rate. They say, we can do it. Now the global rate, we can do that. But the point is that that may not be like a permanent. That does not mean the Chinese judges always want to do it. So that's just one of the toolbox. That means that in the future, some of things were put in the box. And last year we talked a lot about anti-suit injunction, like something really scary. But after a year or two, nothing has been filed for the anti-suit injunction. Now, but we do have something, China, there's something in the pipeline. The most sort of deterrent thing is that China amended this anti-monopoly law, which allows a prosecutor to file a civil action in the court again for this antitrust violations. So but I would argue that's one of the toolbox. That does not mean it will be always used. That's some kind of reality I think the licensors need to be fully aware before they go to China.
Okay, so I do want to come back to explore a little bit of your practical recommendations on how licensors can face this type of action later. But I do want to ask you a burning question that everybody might be thinking about right now is that there is this perception the Chinese government want to protect its national entities, right, national manufacturers and domestic industries. And given such geopolitical interest, how can the Chinese courts be adjudicating a rate that's in fact fair, right? You may call it FRAND rate, but fair for the marketplace.
Again, if you look at the different rates so far has been decided by the Chinese courts, you got to be aware some of the rates, the decision that has not been publicized. For the ones you saw about 10 years ago in the interdigital Huawei case, right? Everybody knows that 0.0192%. Then you got this conversant case, the rate apparently like 12 and 18 times lower than what is decided in the German court. And you also have some other rates. But the truth is that in some other recent decision, apparently the Shanghai court, we got the feedback. The decision made by the Shanghai court in one of the cases involving Xiaomi was actually not that bad at all. So the point is that the Chinese judges, they are actually looking at some of decisions are really a reaction to something. And even like the Huawei decision, right? 10 years ago when I first commented, I said Huawei would not even want to talk about this case a few years later, and that was right. Huawei does not want to talk about interdigital case themselves. So things are changing. That's one of the things interesting in China. Keep in mind, we're not a case law. Those are just decisions. I'm not saying don't be too serious about it, but they could be changing, evolving.
Okay. All right. So, well, next I'm going to Tim. I wanted to see, from an economist's viewpoint of a FRAND rate, right? Because you're not looking at it from a case loss perspective. And so I know we had a little bit discussion before that, just quoting a few cases that who did decide worldwide global rates, setting aside whether it's right or wrong or whatnot, for wireless stack, for 4G, MG, and a couple of the courts, the UK, the US, and China, in I believe the Samsung case, Huawei's case, converging on 6 to 10% stack on the royalty for a 4G MG technology, and 6 to 8%, assuming an average $300 phone comes out almost to $30 for the stack. And we all know in real life discussions and negotiations, no implementers will agree to pay $30 stack. In fact, I'm pretty sure no one has paid that much money for the entire stack. And these are the converged rates from 3 different courts. So I don't have a question really formulated, but I just wanted to hear your viewpoint in commenting on this discrepancy between the court adjudicated rates and the real rates that are being used in negotiations between the parties.
No, Jane, I very much share your observation in that. Also, we did even write a data, based article about it and try to look at different rates of courts that have been set. I think what we always have to think about, also when you think about publicly declared rates, we have seen that now for 5G, and also those rates seem to be quite high compared to what we see in reality and business realities. And even in court, when some of those business realities were disclosed, we had even evidence that it was not even close to $30, rather half of it, even less. But think about a license contract. It's not only a rate, right? It's not only a dollar value in those contracts. These are very complex contracts. They have also business provisions, and they also have a structure. When are you paying? Are you paying for past damages? How much are you paying for past damages? So I find it always kind of like apples and oranges to compare those, litigation, those few that actually are published and that do not settle, to have any actual data point that is close to reality. Why that is and how much use these decisions are, when we think about it, it's so far apart. It's another question. But I think the pure complexity of contracts and comparables in these contracts make it quite difficult to compare that, really. I think that was your first question, how to arrive at a FRAND rate. I think it's of course something that if I knew the answer to it, I'll be a rich man, and we can solve a lot of disputes, because that's actually what people are fighting about. What I see, at least in negotiations of our clients that use, for example, our data, but also in litigation everywhere, is that more and more people pull more information into those negotiations, which I think is good. I think everyone would agree a comparable license approach, if you have real comparables, is something that is the first step you want to do, but more and more people use data, right? And even though data is limited, data we have to be careful with, because we heard that earlier today, not every patent that is declared, for example, is essential, but it helps to start conversations. It helps to get a common ground on understanding who is in the market, what are market shares of certain patent holders, to give some perspective of what is actually going on that is really based on pure data and some facts, and not on some maybe arguments from one side and the other. And we see more and more that it's typically a combination of different information that comes in to help parties negotiate a FRAND rate. And for me, FRAND is always the outcome of a negotiation, right? It's nothing that me as an economist can set in a supply-demand curve, or it's not a secret formula I can come up with. It's really the outcome of a negotiation. And we have to also say, with all the discussions about litigation is the tip of the iceberg, right? We see so many deals get done, so the system is in a way working. FRAND is a framework that people apply, and they come to a conclusion, and sometimes not, and but that sometimes not is more the exception, I would say. So that is actually, for me, it's FRAND, it's really the outcome of that.
So staying on the path of continue to explore whether how useful and the courts adjudicating a front rate. I really want to come to you. You're a U.S. practitioner, has done many trials, right? And then I believe the earlier panels have brought up the ideas having a group of jury members determining front rate or SEPs related issue, which is highly complicated. I believe that we have so many experts here and we can't come to a conclusion on anything, right? So what is your viewpoint on the appropriateness or usefulness of having a jury sitting in a SEP-based case?
Yeah, well, of course, in the US, you're entitled to a jury trial. So if you're going to decide later on that you want to waive your right to a jury, you've got to get the other side to agree. And so there is, of course, always the possibility that the parties could consent to have the judge take, some part of the issue up on a bench trial, as has been done in some other cases, like Microsoft Motorola, for example. So that's always an option. Maybe you carve out the issues, breach of contract, sort of the conduct dispute goes to the jury. Maybe you think they're more equipped to handle that, while more of the rate setting or the mechanics might go to the judge. I think fundamentally, those of us who are trial lawyers know that there's an element of uncertainty, I'll say, when it comes to the jury. The thing that always comes up in my mind when I think about this, especially in the context of FRAND and SEP, is, jury instructions are so important. Who your jury pool is so important. And obviously in the US in patent litigation, there's a ton of, forum shopping that goes on, and people are trying to do their best to figure out what court you want to be in, what judge you're going to be in front of. And so, I think we've seen a little bit of that, of trying to file DJs in certain courts, kind of hope that your jurisdiction sticks and you don't get transferred to another court that you don't want to be. But things like the forum that you're in and the jury instructions that you can get and you're likely to get in those forums are so critical, I think. And we've seen in some cases how, that dynamic can end up resulting in maybe a verdict that you didn't want, setting aside kind of lessons that we can learn from some recent cases about just general trial hygiene. But I think the jury aspect in the US does raise some new sort of different considerations that you don't have in other parts of the world when dealing with this.
So if I were to ask you, if it's your patent, you're a patent owner, and you're trying to adjudicate a front rate or some particular issues relating to the patent, would you prefer to go to a jury-based case, or would you prefer to go to a bench trial? I'm just curious to see your personal viewpoint.
I actually think you should figure out a way to work it out and not be in litigation, frankly, maybe speaking against interest as a litigator. But, I think it's hard to say in the abstract, right? It's going to be very fact-specific. It's also going to depend on what standard you're talking about. We've been talking a lot about kind of the cellular context in particular, and that's where a lot of these cases come out in the US. But, depending on the parties, depending on the patent, depending on where you think you're going to have jurisdiction, be able to get it to stick, I think it really depends.
All right, so Cono, now I wanted to move to you, and then with your expertise on the ITC, right? And then, so there is the perception that the ITC is unwilling to grant or to issue an exclusion order on a SEP-based investigation, and a lot of licensors are shying away from using ITC as a venue for their SEPs. So do you have anything to comment on that perception?
No, just kidding. So I think there's a perception. I think if you look at the stats on since 2013, right? 2013 was that case with Samsung and Apple. The ITC issued an exclusion order. The during the 60-day presidential review, the USTR vetoed it, right? So I think that's like a lingering aspect of this issue. But if you look at the cases since then from the ITC, it's pretty clear that the ITC doesn't have a disposition on SEP, and indeed, by statute, they can't. There's no carve-out in the statute that says the ITC is supposed to treat SEPs as different from standard essential patents, and they treat it accordingly. So there may be a perception, maybe based on that Apple-Samsung case, the 794 investigation, or it may be that there are other options now, right? The ITC is an option. It's been an option for quite a while, but Germany's an option now. China is an option now. District courts have always been an option. So I think they are now just waiting in line like everybody else to get SEP cases. But as far as the commission, the ITC, they've made it clear that they don't have special rules for SEPs. They are not going to treat it specially, and they're going to treat, as they are required by statute, to address any legal and equitable defenses, as they would in any case, and then balance that against the 4 public interest factors that might trump an exclusion order. And if you look at this, again, the stats for the cases since 2013, there hasn't been a case where there's been a violation and the commission said, no, the public interest factor is going to trump this. So I think they just haven't had the volume of cases, and I don't think they've had the right case to issue a violation with an exclusion order.
So what are some of your practice, recommendations for a SEP owner who is willing to go to the ITC and try it out in terms of, best presenting their case to the commission?
So, I mean, like any case, you got to get your ducks in order, right? So you got to do the SEP dance, right? You got to offer up your patents for a FRAND rate. You got to do negotiations for a while, and then you can bring the case. Then also you need to, on the patent owner side, get your policy issues straightened out, because you have to file a public interest statement when you file the complaint, and get your ducks in a row with that as to what your theories are going to be about the pushback on SEPs, and how you're going to marshal that in the case if the ALJ is going to take evidence on that, and how you're going to deal with it on the back end if the commission does issue a violation and does issue an exclusion order or a cease and desist order, how you're going to handle it politically with the USTR and the other administrations that are going to weigh in during that 60-day period. So there's some homework to do. ITC always has more homework than district court. You have domestic industry issues. You have to very detailed complaint. This is some other additional things that you have to do as a patent owner to do the best you can in the case. But the stats at the ITC do not bear out that SEP holders do any worse than they would any place else. They are subject to the same kind of scrutiny as they do in district court cases. They just have extra burdens of domestic industry and navigating through these public interest factors.
All right, so I'll come back to you on ITC in a little bit. I want to now come to He Jing again to, ask for some practical advice, right? So now we are in the Chinese court. Some licensors might not want to be there, but we're there. So what are your recommendations as to best be prepared, how to prepare a case that you will be in?
Actually, it's very important to know the context or the perception of the judges or even general public about licensing or SEP or the FRAND. One of the things very interesting is that the perception about the licensing or even about the Western patent owners. In fact, if we talk about SEP licensing or IP licensing, I would actually go back to 20 years ago when Huawei was sued by Cisco. That's actually probably the first time the Chinese public or government sort of waking up to this romance with IP. IP is not just about the innovation. It's actually going to take money from you. Now, from that moment on, all this perception has been changing. One thing very interestingly, when we were in the court hearing like last year, when we handled one of the cases, one of the big messages we sent to the court is that the Chinese company, the implementer, is not a small company anymore. This is a Western patent owner. It's not that kind of a scary, like a big beast. In fact, if you look at the size, the Chinese implementer is way bigger these days. That's a kind of perception that we have to really make sure the judges understand. At least no one can lie about it. It's not like, hey, this is a big multi-billion US or foreign company going after a smaller Chinese company for money. It's actually, this is a big Chinese global player is, arguing about how much money they should pay. It's really a commercial decision, it's a business decision. it probably should really go to the arbitrators, which is really part of the commercial world, right? Making on the rates. It's not like, hey, the government got to really protect the interest of some poor, smaller Chinese companies. So part of that is really the perception. That's actually very, very crucial. But we're very happy to see, hey, the judges, they got it. Sometimes, they grew up the similar age, they live a certain industry, the perception, right? In the last 20, 30 years, China went through this huge transformation. But sometimes the perception still stick to maybe 20 years ago. So it's our job to change the perception.
Okay. Well, then you mentioned that parties should probably go to the arbitrator or discuss business terms, right? So from your point of view, are there any incentives and any tools that you can encourage the two parties to get together and discuss a consensual rate rather than resort to court adjudication?
Right now, there's really no legal tools, unfortunately. One of the things that we've been telling the arbitration world, even in China, outside China, said, hey, your arbitration world got to really step up. You even failed so far, not even the SEP arbitration world. Even for the commercial arbitration, you somehow have not really gotten put together. This is like a new type of arbitration organization where both the people in China and outside China sort of can go to, can trust. And we got some, in the minds of some Chinese companies, they feel like, going to ICC, going to Zurich to put their case in front of this non-Chinese people. They feel like, how can we get this fair decision? That's kind of a perception issue, right? And at the same time, when we're looking at China's arbitration world, come on, how many foreign companies are willing to put their big case in front of a bunch of sort of Chinese professors or Chinese lawyers depending on the rate? So this is something I think the arbitration world and IP world really got to develop something together. They got to have something like with a global credibility, give some of the comfort, credibility for both sides to go into. Otherwise, hey, the Chinese company want to drag you to the Chinese court and asking the Chinese judges to give some mercy and help them out. And then, the U.S. court, the non-Chinese company want to bring the Chinese, sue them, the ITC, U.S., the U.K., Germany. And you're going to really cause the big trouble between the national courts. One of the unfortunate things for the anti-suit injunction is actually yield so much toxic stuff between the judges, between Chinese judges and the non-Chinese judges. That's very unfortunate. That's probably one of the reasons explains why suddenly all the anti-suit injunctions are going away, even between Indian judges and Chinese judges. It just makes the judges' job so uncomfortable.
Do you think there are any additional solutions to bring all the different jurisdictions together?
I think everybody have to work on their own thing, come from their own side instead of blaming the others. One of the things I think is missing in China is that I think our government has to totally understand, again, from the trade policy side. And we've been through this terrible years in the last 4 or 5 years, during the Trump administration, through a trade war. Unfortunately, the Biden administration seems to follow a little bit about that trade policy, even even worse situation. I think our government has to really get that, helping Chinese companies pay less royalty no longer really helps the trade. The world changed. The beginning, the entry of WTO, hey, we want our Chinese company go do the business around the world, right, at a lower cost with more of a safety. We benefit tremendously from that. But now, when Chinese company becoming all these major global players, we are taking up like 80% like world manufacturing capacity in many, many sectors. We got to be responsible as a global players. And our governments has to get that and educate and having our global players know they gotta have to take on to do the things in a fair way. Otherwise, it's not gonna be sustainable. Otherwise, it's really gonna, oh my God, give rise all this more and more disputes. Somehow drag all the governments in and make things much more, confrontational.
So one of the topics that hasn't been explored this morning so far is the government involvement in coming to perhaps to help with the FRAND issue or to bridge the gap or bring everyone together. I'm curious as to the other panelists' viewpoint in terms of should government be involved? Should the regulatory body be involved? We all talked about SSOs, but curious as to see anyone has a viewpoint on that.
No, I do think they get involved to some extent. There's the DOJ policy statements that come out periodically, and so you have one in 2013, one in 2019, one was floated out in 2021. That does set the tone to some extent, and the agencies do. It's not binding by any means, but it sets a tone and also sets a direction as to where the DOJ may go. So they are addressing it in part, but as far as taking it on head on. I don't have any comment on that. I just, I don't know what to do with that.
So since we're on this topic, are there any correlation between the ITC disposition investigations and various DOJ policies in the recent years?
None discernible. I mean, the ITC is going to do, like I said, it's a creature statute. It's going to do what it's mandated to do. And the policies don't affect, I don't think the ITC is taking it on as some kind of guidance. I think they would consider it, but I think they are going to evaluate for a violation and evaluate whether or not the public interest policies trump any violation finding. But I don't think we've seen any correlation between the public interest, the DOJ statements, for example, and then they've been at odds. The ITC's actions have been at odds with those statements. For example, in 2013, you had the very anti-patent holdup statement from the DOJ and the patent office during the Obama administration, and that policy set the tone for the USTR to veto what the ITC came out as far as an exclusion order.
Well, and right now we don't have any. The policy is there is no policy, right? So it's case by case. I think was the language in the DOJ announcement. But
I think the DOJ has signaled that they are going to seek out the right cases for the abuses to smaller companies or emerging technologies.
Yeah, but I do think that if there is going to be, and other panels have talked about this, any hope for some sort of global tribunal or something that is not a really country by country or jurisdiction by jurisdiction specific solution. I mean, you're going to have governments, regulatory agencies buy-in, right? I mean, you have to get buy-in from so many people. But I think that's where you might see some effort bear fruit.
And so Irene, I want to come back to you in terms of talking a little bit about how U.S. litigation strategy fit in within the worldwide, and it's a common perception that licensors and litigators sometimes tend to shy away from U.S. because of the high cost, discovery burden, and they tend to favor German courts, and you even want to learn German yourself. Any comments as to encouraging a patent owner not to shy away from the U.S. Courts, or just your view on this?
Yeah, I mean, I think that there is, if you are on the patent owner side, you can get a lot of pressure from having a U.S. case, right? Because you can get really big damages numbers here. There have been some really eye-popping damages awards out of courts in cases. You can couple them with non-SEP patents, and you can get big damages awards off of that too. So if you're looking to just get some leverage, get some pressure, I think you can, the U.S. could be part of that strategy. Whether that's a good idea is kind of a separate question. So I think if you just know kind of what you can get out of the U.S., it can be part of a global strategy. On the more implementer side, or maybe on the other side, if you think you are about to be facing a worldwide campaign, or a worldwide campaign has started, and even if maybe ASIs are on the downswing right now, you think, oh, there's still a possibility that an anti-suit injunction might issue. I mean, we have a couple cases at least out of courts in the U.S., one that issued an anti-suit injunction, right? And so you could consider, I think, whether there's any defensive value too in having a case in the U.S. to have, to try to help police different jurisdictions maybe staying in their lanes if it seems like somebody is overreaching.
Okay. So, excuse me, Tim, I want to come back to you and explore a little bit about the transparency issue. Some of the panel members brought up this issue, the outcry for transparency, and it's one of the reasons that you founded IPlytics. So one of the questions I have for you is, how much transparency is the right amount of transparency? Is it enough, right? So one theoretical question I have is, assuming we're in a world that everything is transparent, you have a library of comparable licenses, every license that's ever taken by this licensor is published, you have everybody's rates, and you have all the claim charts, or reasonable amount of claim charts, will that solve the problem?
No, because not all transparency is positive, right? I mean, I think it's percepted that every transparency is good, and I don't think it's always the case. And if you look at two parties negotiating, typically both parties have an interest to keep some things under non-disclosure, right? I mean, a licensee would not like to have his competitors see all their very detailed market data, which is important to determine how much of the patented technology is actually used in products. While on the other hand, maybe the patent holders may not also want to disclose all of the agreements they have. Also for good reasons, because people will end up what they call cherry picking, right? They look at all these contracts and they like this and they like that, and I want a combination of the very best provisions of all these different contracts. So not all transparency may be good, but I think still there is still room for transparency. We are right now writing a study for the European Commission, which is called the SEP Impact Study, which is very much about your question about should governments intervene, should there be regulation, and basically what we do in this study, it's by the way co-authored with Justice Barron here and some other smart economists and legal experts. In this study, we're really trying to determine how much regulation or how much transparency is good for the market, right? And how much would it create also a burden for patent holders, but also for licensees when there would be regulation. And I think it's not easy to answer. We will not always have the perfect, detailed, all worked out answers, but we want to try to provide at least some guidance and consideration of how much it would cost to have more transparency. Me personally, and as you said, I founded IPlytics. We are all about the trying to get information about patents and standards out there to give everyone a better understanding, who actually owns that technology and who should I expect to approach me to pay for a license, right? And I think if you think about patent declarations and databases like the Etsy database, we've seen that also on slides up here. I think from Christian Loy from Etsy. Etsy is one of the best worldwide databases, and it's actually a great database. People keep forgetting it because we have a lot of not so good databases. IEEE, ITVT are databases that allow you to declare just a blanket statement without any specific patent information. From a legal perspective, that's great. All the patents in the portfolio will be licensed under FRAND. I get that, but does this particular party have 1 patent or 1,000 patents? What is the magnitude of their portfolio? That's not known, right? And I think it will not solve all issues or problems people have, but having transparency at least of who owns what, and even if it's not all essential and only partially essential, it provides guidance. And I see that from our clients, which are, by the way, licensors and licensees. Starting with data is a good way to start a negotiation. It will not be the holy grail, it won't give you the result of what FRAND did, but it can be a starting point, and it can help. And I think, I also don't want to say there's a broken system and we have so many problems. I think there's more deals done than litigated, but still, SEP owners wait years for their royalties, sometimes 10 years. Licensees, on the other hand, have little understanding what they will end up paying. They implement a standard, and there's certain risk to certain royalties in IoT that even know, will I pay? Will someone else in the value chain pay? Those things are all unknown, and the more we can go towards some transparency, good for both sides, the more deals we will see get done, the faster we will see those deals to get done. I think no one should wait more than 2 years for the money. Well, on the other hand, the licensee should have also enough information to make sure they don't pay more than their competitors, for example. And everyone ends up paying, because then they have otherwise a competitive disadvantage against the others. So I think there's still room for, let's call it improvement, and transparency can do some part of improving that, or going towards more improvement of that whole process.
So He Jing, so Tim mentioned a little bit of from the implementer's point of viewpoint, having that transparency can potentially help bring the negotiation a little bit closer, right? And we also heard from other panelists, and it's not a surprise to anyone, that a lot of the implementers, and particularly Chinese implementers, they're very vocal about, I'm willing to pay, I just don't want to pay more than my neighbor that's paying. So can you share a little bit of your view on your experience on dealing with the Chinese implementers and their view on what could potentially help to bridge the gap to come up with what they consider as the friend rate?
Actually, was speaking to Tim about this, right? We were talking about how many people are actually using IPlytics in China, and how many law firms using that in China. So maybe we'll be the first one to use it in China. The point is that we actually, in our part world, people actually really need to get to know the data, the transparency, because not many companies sign the deals, right? There's probably the limited sort of China-based data. So that's what people probably struggled with. But I think right now the transparency of the data may be offering maybe a very important access to cause certain kind of progress, especially when it comes to automotive industry licensing. I do want to say something about this automotive the industry. I think China now stands in this huge, gigantic opportunity, probably for the very first time in the history, that we have this is a very unique leading position in one of the very important industry that are having all of the China, the sort of the products going to the world, right, for the connected cars, electric vehicles. I think the industry and the government do not want to screw this up simply because of the royalties, plus maybe because of data privacy issues. I think that's probably the message our government and the industry people are fully aware of. Now, what they really need is this kind of enablement, I would say, the enablement of all the data. Want to make sure they got the fair deal. So that might be the opportunity. This is actually very different, I would say really different from how this handset, the mobile phone licensing probably started years ago. So now China has this very different gravity, the very different position when it comes to this the electric car industry, connected car industry. And this is part of the time maybe some kind of peace can be accomplished, and some kind of money can actually really go to the western part of the patent owner, probably especially Europeans. Sometimes I really think the licensing work is more of now, unfortunately, it's in the China-European affairs, less so about Americans.
So I definitely want to leave a little bit time for the audience to ask questions. But before I go to the audience, I do want to ask from each one of you that if there's one thing that as a takeaway that you want to offer to the audience, or just from the friend and SEPs, the discussion, what would that be? I'll start with Tim.
Yeah, sure. I mean, I think this panel here should be about the global overview, and you ask about should governments intervene, and what we see is, I mean, we all agree FRAND is a global rate and it's negotiated globally, and that makes it so tricky with all these local courts and local governments. And I think governments should really understand that it doesn't make sense to pull everything in their country and get influence, because then we really end up in a trade war where each region tries to get some influence on FRAND rates, and then we're fighting about all that. What I would love to see is more of a global approach also from governments. Maybe the World Trade Organization can help here to find something that is global from the beginning, that everyone can relate to, rather than fighting in these local courts. And then, of course, because it's my topic, transparency in some areas, not in all areas, but at least when it comes to data on patents declared and standards published. The whole world of standards is also very public, very open. Why not having that in SEPs too?
Okay. Irene?
So I have a thought, which is actually a question, which is something that we haven't talked about at this conference really yet, and I'm not sure that anyone on this panel is properly got the expertise to talk about it. But the UPC is coming out in April. That is going to be a whole regime change in Europe. What is that going to do to all of this, and is that just going to further fracture the global landscape?
Well, I don't think I know the answer. But it's definitely something that we all wonder, right? Like the current regime is favoring which side, what's it doing, what the actual impact is. I think the answer is who knows, right? We can only hope for the best because the intention is to help, certainly, right? To make things more efficient. Tim? I'm sorry, Cono?
So I'll go by Tim. There's 2 points, and it's just because of my jurisdiction. The ITC, it's open for business for SEPs and also for respondents who are defending against that. And on the respondent side, you do have a lot of things at your arsenal to defend against. But on a kind of a transparency bit, I'm just going to take 2 points if you don't mind. On the implementer side, as many of you know, it's putting transparency aside, there's a lot of self-help things you can do, right? You can seek most favored nation clauses. You can condition your rate on the licensor licensing up your competitors, at least in a certain amount of times. And we tried those self-help things a lot on the implementer side with less than perfect data, right? We're not going to have exposure to everything. And even if I did have a lot of licenses in the space, they're all different, right? What's FRAND to one implementer is not FRAND to another. And they all have carve-outs, they all have exceptions, they all have conditions. That's really hard to parse. So what we try to do on at least the implementer side is give ourselves a couple of clauses or negotiate a couple of clauses where I wouldn't say have escape hatches, but ways to renegotiate if things don't develop well or don't develop in a way that both sides were anticipating.
And He Jing?
I just, as someone as doing both the law practice and also advocacy, we saw the two different kind of conversation in the courtroom and outside the courtroom, like between us and the policymakers. I do think this kind of conversation, got to really bring over to China. There are also a lot of conversation in China about FRAND, but we really more the true transparency. And the decision makers really got to know the reality, the truth, all this transparency, and then all the considerations. That's probably the only thing that can make this forward.
Okay. All right. So I want to open up to the audience to see if anyone has any question for our panelists. Nothing about China?
Dragons? Anybody got a dragon out there?
All right. Well, thank you. In this case, I want to thank our panelists for sharing your thoughts and have this discussion. And it has been really interesting. And thank you for the audience for listening to us. And it's really hard to step up after the judges panel. I'm not sure what more we can say. And also thanks to the symposium, the organizer, the board, and a big shout out to thank really the mastermind behind putting together this very much what I call the dragon slaying agenda. So thank you.
Thank you.
Before we close the 2022 Global FRAND and SEP Symposium, I just want to acknowledge some people who helped make this possible for all of us. I can't read all the names, but you'll recognize the faces. It's been wonderful to see old friends and meet new friends. Another acknowledgement is to our platinum sponsor, McCool Smith, who, like all our sponsors, helped to make this event possible. I'd like to thank Cater2, our caterer, and FN Tech, who did a wonderful job producing this event. Thank you. to all of them. And of course, thank you to the executive director of Bauz IP Law, who put in an enormous amount of time to make this such a fabulous event. Thank you, Maria, for your help. And now the Computer History Museum has done a wonderful job as well, and they're leaving 25,000 square feet of their museum open for us during the networking reception. So thank you to the Computer History Museum as well, and we look forward to seeing you downstairs where there will be not so small plates to enjoy. And thank you for those remote participants as well who joined us from 3 continents, as well as our speakers and moderators who also joined us from 3 continents. Thank you very much. Enjoy.